Okay, hello everybody. This is week 2 of the ATAC Roundtable discussing the class action lawsuit brought by Arizona prisoners against the Arizona Department of Corrections in the state of Arizona regarding health care, mental health care, and the use of solitary confinement, excessive use. We are again joined by an extraordinarily esteemed panel. First, we have Jimmy Jenkins, the Arizona Republic reporter, formerly of KJZZ, who has been covering this story for the last 5 years, and has probably the best fact knowledge on all of these issues because he's followed it so closely. Welcome, Jimmy. Along with Jimmy, we have Julie Gunnigle, Arizona attorney, former law professor here in Arizona, who has also been following the case. Welcome, Julie. In addition, we have Stacy Scheff. Stacy is also an Arizona civil rights attorney who specializes in prisoner civil rights cases and with a law firm down in Tucson. And Billy Peard, also from the Scheff law firm, down in Tucson, working on prisoners' civil rights cases. Thank you all for joining us today on ATAC's Roundtable on the trial. The first thing I would like to do is go ahead and give it to Jimmy. And Jimmy, if you could go over what happened this week in the trial.
Sure. 3 days of testimony this week. On Monday, we heard from two currently incarcerated people. It was Jason Johnson, who's at the Iman complex, and then Dustin Brislin, who I believe is currently at the Tucson prison. But they both testified to the struggles they face dealing with mental illness and the ways that those struggles have been exacerbated by the conditions of their confinement and their lack of access to adequate mental health care treatment. Mr. Johnson talked a lot about how staffing shortages were impacting his ability to receive programming, to get outside of his cell. He talked about how he spends so much time in his cell. I believe he also told the court about how he was one of these people. We keep hearing from folks who are incarcerated. Maybe they were actually at a good place where they were getting some adequate treatment, but then because of a custody increase, they're then sent to a different prison, which doesn't have access to those same programming and mental health staff. So that was a recurring theme here. It's like, actually there is some decent programming going on, but it's only like 1 or 2 different locations. And, if you're lucky enough to be there, then that's great. It actually sometimes works really well. But most of these people don't have that access. Some of them even had it taken away because of security classification increases, which we heard more about in the week. But Johnson and Brislin both talked about something I thought was really disturbing, really kind of stood out to me as the biggest news of the week, probably, in that they both testified very confidently that correctional officers and even healthcare staff have been encouraging these people to self-harm. And I say specifically, we heard examples of incarcerated people who are on suicide watch. So they are, already in restrictive custody kind of situation. They have displayed some kind of behavior that has caused them to be in an even more restrictive room with like just a smock on and, none of their possessions. And they're actually supposed to be being watched by a correctional officer. We learned about how when it gets that bad, there are people who are doing things to make it even worse. And these are people that, quite frankly, are probably near death because we have determined that they are so, struggling with their mental illness that they have harmed themselves. They could potentially commit suicide. So, it's already obviously it'd be shocking to all of us to hear that a correctional officer or a mental health care worker were goading people into harming themselves. But then, what we're talking about here is the most sensitive population who's at risk for all that. That's who they're kind of messing with. That's the testimony we heard, essentially. Dustin Brislin is someone who I've communicated with, I think, for the longest since I've been a reporter. And just, incidentally, interesting guy, really good artist. We heard about in the trial how I don't know how ethical this is, but they're allowing him to draw photos of like the wardens and the deputy wardens. And so, obviously even the prison thinks he's a really good artist. And we heard that he was happy that they encouraged that behavior. But this is someone who I've quoted from extensively in the past because he's really good at articulating his challenges with self-harm. So just to talk about that briefly and to warn everyone, I'm going to now talk about what he has taught me about those challenges. And one of them is that he just feels compelled to cut his arms and he bleeds a lot. And he says sometimes he does this to get attention. Sometimes it's because he is so distressed. But he talked about how he is known for struggling with this self-harming behavior in the prisons. And guards will basically do things to push his buttons. And, he told the court that he thinks that they wanted to see how badly he could harm himself. Like, he's saying things like, oh, cut yourself deeper. How much are you going to bleed? I won't go into it more, but basically he told the court these really shocking things. So correctional officers and healthcare staff. And then we saw videos again where it seems that the staff have decided that it's easier to escalate a situation of someone experiencing a mental health challenge. It's easier to exacerbate that situation. Then they can kind of call an emergency response as opposed to responding a different way. So, the whole goal here should be to de-escalate incarcerated people, de-escalate these mental health care patients, and have them not harm themselves. But we just learned several really, I think, concrete and believable examples. Like Dustin Brislin, for example, he told the court the full names of officers, 9 or 10 people that he claims harass him. And this is in a prison where he says he's getting better treatment than he was previously. So just really brutal stuff. They both described how they are often pepper sprayed. Chemical agents are used against them. We actually saw again this week more videos of another incarcerated person who's been featured who is displaying self-harming behavior. He would walk to the front of a self-watch cell and bang his head into the door, and he was just kind of doing this repetitive behavior. And the way to deal with that, or the way the Department of Corrections deals with that, we learned, was by spraying him with pepper spray, shooting him with a pepper ball gun. And we saw evidence that, there was no real effort to bring in a healthcare professional and try to get him to just stop doing that behavior, to try to talk him down. One of the medical experts we talked to said, we've documented here that this happens so much. Why didn't anyone ever sit down and say, you know what, Mr. Muhammad is harming himself every day. We're shooting him with the pepper spray every day, and we're taking him into medical, and then we take him back to his cell. And this has happened like 40 times in a row. Why didn't someone at the administrative level ever sit down and say, hey, we got a problem with Muhammad here. How can we make this better? It's just like no one apparently is doing that. They're just allowing the same repetitive behavior to damage these people who are already so damaged. We also heard from Martin Horn, who is a former prison administrator, works as a consultant now, but he talked about how the security classifications in Arizona prisons end up putting a lot of seriously mentally ill people into very dangerous situations. He said that custody levels are calculated on many different factors, and then within the Arizona Department of Corrections, it's a very, just a very difficult process to follow. Basically, he told the court, it's really difficult for people to navigate this custody level process. They don't take very good notes on how they do it. They're supposed to be reviewing everyone's security classification and making adjustments as necessary. It's not really clear the practice they're using to do that. And again, they're not taking very good notes. And then we learned about these another factor called overrides, where based on your calculation of your crime and all the other factors they used to assess when you were coming into the prison, they decided, well, Jimmy is going to be a medium custody inmate. But then they do an override for X, Y, and Z reasons, and then they would classify these people up to maximum custody, which again reduces their movement. Horn talked about how it's actually a very expensive use of public resources, and we should, and for human rights reasons and other reasons, we should not be putting people in solitary conditions. But he also just talked about how if someone's at a really higher custody level, you've got to pay more correctional officers to walk them everywhere. It's just way more labor intensive. So, but we learned that when they're assessing when to use these overrides, they're using factors that they already assessed them on. So they're basically kind of like double charging them for things that might go against them. And he said, this doesn't make any sense. Why are you doing this? And essentially what we learned from Mr. Horn there is that, the custody system is really hard to track. Oh, and the other main takeaway that I thought was of importance is that when an incarcerated person is reclassified, they are not really told about it. And they're supposed to have a chance to appeal that classification, and they're not given that appeal. And he said, he's like, well, not many incarcerated people are going to appeal their reclass if you didn't tell them they had the right to appeal, so because I think he was asked on cross-examination about that. And he said, well, you're not even telling them that they have the opportunity to appeal this. But one of the main things he said was prisons are very expensive public resources. They have a profound impact on the people who live there and the rest of society. And then there was continued really extensive cross-examination of Mr. Horn. And then we get to Wednesday, and we heard from Dr. Todd Wilcox. And so we've heard about custody, we've heard about staffing, we've heard isolated cases of just general poor health care. But Dr. Wilcox kind of, in my mind, tied these systemic problems from a medical point of view together. He talked about different case studies, but one of the things that really stood out to me was he said he kept finding younger men in their, I think, 20s and 30s who were dying from testicular cancer, or having really bad complications from testicular cancer. And he said, as a medical professional who has treated that kind of cancer before, it's actually one of the most treatable. So he, not only was he finding younger people dying from this, but it's from a cancer that you typically shouldn't die from. And if you're out in the free world, there are all kinds of ways to prevent you from dying from testicular cancer. But he talked about one just really graphic and sad tale of a person who did what any people hopefully who are taking themselves would do. He was doing like a self-check, found a lump, reported it. It took months and months to get any sort of, even to be seen by a doctor, or not a doctor, a nurse. When they finally started doing tests, they lose his test results. At one point, they confuse him for a pregnant woman, even though these are the healthcare professionals that are supposed to be tending to his care. Things got so bad, he finally goes to the hospital, has surgery. They find out it's cancer. And another big thing that is a recurring factor in this trial is when he returned from surgery back to the prison, they're supposed to send you back just like you would any of us and do like a checkup. Like, how did that go? Where should we go from here? And that didn't happen. And this is, Centurion is accused of doing this, Corizon is accused of doing this, but it's these discharge directions not being followed. It's like a miracle if anyone goes to the hospital in the first place, unfortunately. But when they do go and they come back, the state isn't doing what it's supposed to do to make sure that that was worth it. So you put in this really expensive investment. You sent someone to the hospital. You had this expensive surgery, and it's going to be all for naught because they just aren't following through on it. So, it kind of talks again to this problem with continuity of care. So they don't send him back. He doesn't get to go back to the oncologist like he's supposed to. There was more cancer. It spreads to his stomach, and he dies at 30 years old. So that was just one case. He also told us about. He went extensively through the case that we talked about last week about the woman who was delayed treatment for her MS, and now she's essentially immobile. He just kind of went line by line through all the different ways that we had failed this woman. And the last point I'll make is he brought up this example of how at the very beginning, someone did make a note in that woman's profile about like, well, maybe this is MS, but they didn't follow up on that. But what Wilcox said this was a testament to a problem of is that in the Arizona prison healthcare system, nurses have a great deal of power to be the final decision maker, is the way he kept saying it. And he said it kind of goes reverse to what you would think or the way the rest of us experience healthcare. He said, like, imagine if you went to your doctor and the nurse stopped you in the lobby and said, I'm not really sure if you need to be seeing the doctor, based on the things that I've just evaluated you on. And imagine if that nurse had the power to shut you down, even though you already paid your copay and you have to go on your way, so that's essentially what incarcerated people are dealing with. They are paying their copay. They are seemingly, asking for legitimate help. And people with less training are the ones making the decision on whether they get sent on to people with more training. And it just leads to this whole litany of problems because those people just don't, they don't know how to diagnose certain things. And Wilcox said, not only is this poor practice, but it's legally outside the scope of what nursing licensure allows for. So he was essentially saying that Centurion is operating illegally. They're, empowering their employees to do things that are outside the scope of their legal licensure. And he really drove that point home because he said it's these frontline intake encounters that incarcerated people have with a nurse. They need to be, in his opinion, they need to be funneling more people onto the provider, someone with more medical training, to make these life or death situations. And if you don't, you're going to keep having instances like what we're hearing about of delayed care, improper diagnosis, people dying of things that they shouldn't be dying of.
Yeah. Okay. Wow. That is incredible. Thank you, Jimmy. There's a point that you brought up there that I want to hit on real quick that may be lost on a general audience. And so I want to reaffirm this for a lot of people. In Arizona, in the Arizona Department of Corrections, if you go to seek any type of medical care, you have to submit a form, which is called a health needs request. And when you submit that form, you have to sign it. And on that form, it says that you don't get to dictate any of your treatment whatsoever. And it's a $4 charge. And $4 doesn't seem like a whole lot of money to those of us that are out here. But you have to consider that $4 charge is being charged against somebody that makes 10 or 15, maybe 20 cents an hour. So, or maybe 25 cents an hour. So if you take that out to somebody that's making 20 cents an hour, paying $4 versus somebody that's making $12 an hour, paying a $25 copay or $10 copay, it's almost like the inmate is paying like a several $100 copay. It's extraordinarily expensive for the men and women in the Department of Corrections to even access health care. And that money is likely the money that you were going to use to buy hygiene or some other thing in your budget. So when Jimmy is talking about submitting one of these health needs requests, and then you get in, and when you say nurse, Jimmy, there's gradations of nursing as well. There's an LPN, there's an RN, there's several different types. And the ones that do triage in the Department of Corrections are almost exclusively LPNs. So that is, of the gradations of nurses, this is also the one that's on the lower levels as opposed to, say, an RN. And so this is the person that's making that determination of whether or not you go to the next level, which is to seek medical care, which is extraordinarily problematic in our system. They do need a triage, but they acting as the traffic cop is also extraordinarily problematic. Jimmy, there was a development today in the court. Can you tell us what that development was today?
Yes, there's a calendar update. So things have been going slower than both the plaintiff and the defendants, I think, anticipated. From my perspective, it just seems like the cross-examinations have been going very long. The defense is spending a lot of time trying to impeach the plaintiff witnesses, which is what you do in this kind of situation. And those impeachments have just been very extensive. And so things are stretching on longer than anticipated. I believe the court was hoping to have things originally wrapped up on November 19th. So that would have been 3 weeks of trial. They had already realized that wasn't going to happen. So they said, okay, we're going to come back on the 22nd. It looks like things are stretching on even more. Both sides have a certain amount of time allotted to them. I believe it's 50 hours to do their testimony. And, they're just looking at the clock and realizing that that's not going to be accomplished in time. So Judge Silver said, okay, we'll go through next week, the 19th. And if we can wrap it up, fine. But if you can't, we will start back again on December 7th. And I think just based on what I know the defendants want to present, I think that'll happen. So we'll have 5 days next week, and then no court for 2 weeks, and then it'll begin again on the 7th. And, I could see it going on for maybe even another week after that. I'm not sure. But, so anyway, that's the news.
And Jimmy, how many more witnesses does the plaintiff have? Do you know?
I think we were actually on the last witness because the defense was getting ready to, I think the defense is going to call witnesses on Monday. And there are no, there are no remarks that have to be made or whatever after you're presenting your slate of witnesses. And there's going to be no closing remarks either. But so, yeah, I think the defense is going to start on Monday. We could see Director Shin. There are deputy wardens that are supposed to be giving testimony. They have to finish up the cross-examination of Wilcox, I believe, and then they might get to Director Shin. If not, then I assume he would be moved or bumped to Tuesday. But as we talked about before, I think that would be a big opportunity for a lot of us who watch the Department of Corrections to get information right out of the administrator's mouth that is not currently or is not normally available. So that would be a big one to watch. And I'll make sure that I'm posting calendar updates, but that's looking at Monday or Tuesday.
And I'm sorry, Jim, you might have said this. Is Director Shin listed as a plaintiff's witness or as a defendant's witness?
Defendant's witness.
Defendant's witness. Okay, that makes sense with your time.
Yeah.
Okay. Very good.
It says he's down for like 40 minutes, and then I think about that much time of cross-examination. But there are just so many things you can imagine that plaintiff's attorneys probably want to ask. And I remember back when Charles Ryan was actually called up on the stand during an evidentiary hearing, he actually said some things that I just wrote down and we printed. And when they came out, he realized that he'd either misspoke or been misinformed, and he had to correct that in the record. So obviously it's a big deal when a powerful person like a department director takes the stand in a federal court. So I think everyone, if you're interested, you should definitely take advantage of the call-in option, contact the clerk, and you can call in and listen along. So I think that so to me that's going to be one of the newsiest, most interesting days of the trial, probably.
Oh, I think you're absolutely right.
Can I just comment on how ridiculous that is? That if I understood you correctly, Jimmy, that Director Shin gets 40 minutes, plaintiffs get to question him for 40 minutes, and defense questions him for 40 minutes?
I just remember looking at the schedule published in the docket from the defense, and I do believe it only said 40 minutes, whereas other people have been going on for hours. So I don't know if that's still an accurate calendar.
And
yeah.
For the general audience, that's not atypical to have someone in a high-level directorship position, to have his or her attorneys carefully guard the amount of time that they spend. But that's excessively ridiculous, excessively short. And by contrast, I'll just point out that former President Trump, I think recently was required to be deposed in a lawsuit that did not involve his presidency, but the same dynamics apply, right? People in higher positions, the attorneys fight really hard to limit the number of hours they spend testifying. And just by contrast, I think former President Trump recently spent 3 to 4 hours, was ordered by the court to spend 3 to 4 hours in testimony.
Well, I thought it was out of whack or out of balance because, they've spent 4 or 5 hours cross-examining some of these medical experts. It's just kind of this minutia, but painfully long. So I was surprised at that. And he also has been, he gave a deposition as well. So I don't know if that factored into the timing and all this, but I don't know how long that was, but I know that he has given a deposition.
Okay, very good. Thank you, Jimmy. That was exceptional, as always, wrap up. I really appreciate that. Okay, let's go to law school for a minute. Julie, I need you to put your law professor hat on for a second.
Oh, Lord. All right, let's do this.
So let's talk about what this term means, case in chief. What do we mean when we're saying case in chief?
Sure. So, in any lawsuit or even any criminal case, there's always a burden of proof and a plaintiff and a defendant, right? And the idea behind that is that your plaintiff typically has your burden of proof. In this case, the plaintiffs do by a preponderance of the evidence. And for those following along at home, that's not the beyond a reasonable doubt standard. That's just more of a more likely than not standard to be able to prove up their claims. So the plaintiffs will get both the first and last word in the trial, and putting on their case in chief is that first word. It's framing the case, and we've kind of gotten some hints as to what they're thinking, right? I think the first day tipped most of us off because that was the most controlled day and most controlled order, which was that we were going to hear both qualitatively how bad conditions are, and then quantitatively through experts how terrible conditions are. And that those themes have been interwoven throughout the entire rest of the case in chief. But in theory, your case in chief is supposed to be hitting on every single bit that you need to prove, such that there's been at least some evidence such that a judge could find in your favor on all of the claims that you've put forward. And it sounds like we're very, very close to the close of that case in chief.
Okay, very good. So, and inside your case in chief, when it's your side's case in chief, you're calling your witnesses. The other side gets to cross-examine them, and then you get to do redirect examination. Is that right? So
exactly. And that's kind of how it's going to follow too when we talk about what happens next. The defendant is going to be able to be put on their case, call their witnesses, and the plaintiffs will have the opportunity to cross. And then, I don't know what guardrails have been put on by the judge as to whether or not there'll be the opportunity for rebuttal and how that's structured, because that can be very discretionary. But the plaintiffs could, in theory, have that last word if there was anybody else who needed to be called.
Okay.
Or any other issues that needed to be cleared up. If you need to recall a witness, that's the time to do it.
Okay. Billy, so in discussing that, we had Julie mentioned the burden of proof here, which is a preponderance of evidence, which means more likely than not, 50.1 versus 49.9, right? Which ironically, by the way, for all of those of you who have a loved one in prison or have been in prison yourself, that's the standard of proof that's used in our disciplinary there. Is it more likely than not that it happened? Yeah. And the good news is we see a lot of guilty people with disciplinary infractions, or at least people that have been convicted of disciplinary infractions. But Billy, when we're talking about the preponderance evidence and we're talking about the case in chief, if you were putting on this case, what was the plaintiff's burden? What did they need to get? What was that qualitative and quantitative information that they needed to get to the court in their case in chief? What do they need the court to see?
Well, Julie's absolutely right that we use the term preponderance of the evidence to describe what a civil plaintiff in a civil lawsuit oftentimes has to prove to prevail. However, in this case, there's kind of grafted on top of that standard an additional standard that I think Stacy did a very good job of describing last Friday, which is what we refer to as the deliberate indifference standard, which almost converts, I think Stacy and I have talked about this in the past, it almost converts what is a civil, that lower threshold for civil cases. Julie just talked about in civil cases, you don't have to show beyond a reasonable doubt as you do if you're a state prosecutor wanting to put someone behind bars. But this deliberate indifference standard has almost grafted on top of the civil, almost like a beyond a reasonable doubt equivalent. We don't use that terminology, but it's almost equivalent to that in some senses, because this particular case, the plaintiffs have to show that there was a deficiency in terms of medical care and specifically in terms of mental health care, as Jimmy was describing. And that, under the federal constitution, requires proof that the prison system fell below, way below. And as Stacy described last week, it's not enough for the plaintiff to say, oh, there was systemic problems with, not providing the standard of care, not in other words, doctors and nurse practitioners and nurses providing care that is sort of below acceptable in the practice, in the industry, in the medical profession. Showing that in a normal life situation would be enough, but not in this case, not in this circumstance. You have to go above and beyond. You have to show not only did they fall below sort of the acceptable professional standard of care, but they actually fell even way below that, so far below that it violates the Constitution, which is, we use the shorthand term deliberate indifference to describe how, just so woefully, so inadequate, so beyond civilized, what we expect of civilized society. It wasn't just a modest deviation. It wasn't just leaving a medical instrument in someone's abdomen during surgery, as you kind of hear about in sort of the traditional medical cases. It would had to be way beyond the pale, and it's a hard standard. It's a hard standard. But I think we'll discuss more throughout the night and throughout the weeks. But I think if there is a case that can prove it, it's probably this case.
Wow, very good. So, Stacy, when we're talking about that, when we're talking about deliberate indifference and we're meeting the standards, so as Billy said, we have to just prove it's more likely than not that something happened, but beyond that, we have to get to this thing called deliberate indifference, which is a subjective standard, saying, as we talked about last week, as you defined so well last week, that the person knew that this was happening and made a deliberate choice to be indifferent to that. And you have to prove that in court. But why, when we have all this stuff, when we have all this evidence that's coming in of these absolutely deplorable conditions that I think that most of us out there, most of the lay people out in the audience would agree, this is horrendous treatment. But it doesn't necessarily win a case, necessarily. And so the reason is that there is a long history of cases from the United States Supreme Court and the lower courts that have also made it extraordinarily difficult, beyond just beyond deliberate indifference, on how we can proceed in these trials. And there's the 1994 Prison Litigation Reform Act that's out there. So can you talk about that? Can you talk about the Eighth Amendment jurisprudence, and I'll let you explain that, Eighth Amendment jurisprudence, and how difficult it is to win these cases beyond just what we've talked about already?
Sure. Yeah. So the standard for winning an Eighth Amendment case, which is the amendment that provides prohibition against cruel and unusual punishment. So that's the standard for anything that is apart from the criminal punishment that is imposed on a prisoner when they're convicted for a crime and sentenced to prison. So when they're denied health care, for example, their criminal court didn't say anything about the kind of health care that they should get. That's the Eighth Amendment floor that comes in, that it can't be unconstitutional care. It can't be so bad that it amounts to an additional punishment for the crime that they committed just because they're in prison. So in the 90s, there was a big crackdown on crime and a big push for politicians to show that they were tough on crime and law and order candidates, because that's how they realized they could get elected. And so their platforms became all about tougher punishments for crimes, more time in prison, and also making it harder for prisoners to complain about the conditions of their confinement. And so it was 94, 96, somewhere around there. The Prison Litigation Reform Act was passed by Congress in order to limit the amount of civil cases about conditions of confinement that prisoners could file in court. And so it adds on all of these hurdles that prisoners have to pass before they can sustain a case in court. Things like they have to give the prison a chance to resolve the issue first. And if the prisoner doesn't go through that, it's called a grievance process, then their case, if they file it in court, gets thrown out. Bam. They don't even get to see the judge. It's screened out. And so, it's things like that, and then the other thing, the other big thing is this deliberate indifference standard. So you're talking about the difference between like criminal burdens of proof and civil burdens of proof. The OJ case is one that's usually given to illustrate this, because there was both a criminal case for murder and a civil case for wrongful death. And so when you're dealing with the civil case, you're dealing with a more likely than not standard. With the criminal case, you're dealing with a beyond a reasonable doubt standard. So civil, it's lower, criminal, it's higher. But then when you're talking about the burden of proof, in normal civil cases, it's your violation of the standard of care or the negligence standard. But then when you're a prisoner, even though you've got this lower civil standard of more likely than not, you've also got this, you've got to show it's more likely than not that there was deliberate indifference. So then it brings, like Billy was saying, it brings it up because you've got to show that element of intent that you don't have to show in a mere negligence case.
Right.
So you've almost got to show like a criminal standard that they intended to hurt you.
Yeah.
And so many of my clients say, like, if somebody had done this to me on the outside, they would be in prison. So it's things like, killing people. Right. Like Jimmy was saying, people are dying from not getting care. And I challenge anyone to tell me how that's different from negligent homicide. And so, certainly if there was any fairness in this system, there would be criminal penalties for people who deny medical care and cause other people to die, not just the civil remedy.
Right. And that's kind of an important thing there, and that's something, Julie, you and I have discussed before recently, which is that if this is not a money damages case, but since we're kind of on that topic, because here we're only asking, the plaintiffs are only asking the court to enter what's called a preliminary injunction. Is that correct? All right. So what is that, Julie? Tell everybody what a preliminary injunction is.
Well, it's an order saying that you either have to do or refrain from doing a certain thing.
Yeah. So it's an order to comply with this, whatever the court's telling you to comply with. Okay. And so, but if this was for money, which many cases are when we do individual civil rights cases for people that are incarcerated, they often seek out money damages as a method for recompensing whatever harm that they've gone through, because we don't really have any other ways. We can't undo the harm historically. We can't go back and fix it. So we have to compensate it, and that method is used as monetary. So, but the problem is that when you have a suit and one person is found to be liable, they or the person, the company or whomever is indemnifying them, is insuring them, is responsible to pay that judgment out. So there is some sort of economic harm or loss or damage to the person that has to pay that judgment if one's found, they're liable. Here we don't have that, do we? Do any of these state officials ever pay a dime out of their pocket, or these contractors pay a dime out of their pocket for their bad behaviors?
Nope.
Who pays?
And in fact, in so many cases, and up until, what was it, Monell, there was this idea of absolute immunity. And you hear that term absolute or qualified immunity, two different types of immunity that we use when somebody has been aggrieved and wants to sue the government.
Right. And that means that they're immune from any liability, right? That they're immune from being found liable for whatever it costs. So who pays when there is damages awarded in one of these judgments?
You or I, typically. There are instances where government and subdivisions of the government are insured against it, but otherwise, it's the taxpayer, it's us as the infinite deep pockets.
Right. And right now, who is paying the defense's legal costs?
Right? That's us. to a private law firm.
So
do we have a total on that? Just by, I mean, I'm sure Jimmy would know. Do we have any sort of estimate as to legal costs at this point?
As of March of this year, total legal costs exceeded 21 million. And I think it's like, I think we need to just remind everyone, I forget this sometimes too, but like we're paying for both sides, so it's like we're paying John, did you say this? But someone said we're paying to sue ourselves or what, so it's just kind of stunning when you think about it. I mean, but it's, I don't know what else to say about it, but we're paying both sides.
And that's exactly
costs a lot of money.
That's exactly what I'm illustrating here, is that this is where we're at, right? And this is a policy conversation, but that's where we're at. We're in a place where the Arizona citizens are suing themselves and funding this whole lawsuit because the elected officials that the Arizona citizens put in place are refusing to do the things that are necessary to remediate these problems. And this is what's happening, is we're all we're paying for all of this. Go ahead, Jimmy.
Another interesting aspect of all this is that records I've received show that more than 10 million has been paid to outside counsel for the defense, which is the Phoenix-based law firm Strucklove and Bojanowski. And I can never figure this out. This is one of my great unsolved mysteries, but I received some communication between the Department of Corrections and the Attorney General's office way back in the day that shows that Mr. Struck, I believe, reached out to someone at the state and said, yes, I can. It was him responding, I think, to them requesting him to do it. And so he said, yes, we've done this. And they do this kind of work in many cases all over the place. And they are seen as experts in these kinds of proceedings. And so it makes sense to me that, okay, you would go to a firm that actually happens to be here in Phoenix who are the experts in this field to defend the state. But I've never been able to figure out why the Attorney General's office is seemingly totally absent. And Judge Duncan, previously on this case, he brought that up all the time. And he would always say, you got the Attorney General out there, he's got an army of employees, but yet here we are depending on this private team of attorneys. And I don't know what the cost comparison would be there, but they're all charging rates for high rates for those services that one would think you could instead redirect your already salaried employees of the Attorney General's office to be doing this in work. But instead we're paying $400, $500 an hour for a private law firm to do it. And I've never been able to figure out why that is.
Right.
Well, I just like to point out as well that the plaintiff's attorneys are also the experts in their field. They did the California class action that went to the U.S. Supreme Court and was, California was forced to release prisoners because of the overcrowding problems as a result of that. Just in terms of the state's bad faith in this lawsuit has started from the absolute beginning. Because I remember when they started in 2012 and I was volunteering on the team, and the team reached out to the state and said, look, we're preparing this class action. We want to enter into an agreement with you about those administrative remedies, the grievances that I mentioned earlier that the PLRA requires. They said, obviously, we're not going to be able to have everybody involved in this lawsuit exhaust their grievances on every issue that we're going to raise. And so the state said, sure, we'll enter into a tolling agreement with you to toll the need for those types of administrative remedies. And then as soon as the lawsuit was filed, the state files a motion to dismiss for failure to exhaust administrative remedies. And the plaintiff's attorney said, hey, wait a minute, we've got this tolling agreement. And the state's response was, you should know better than to believe us at our word.
Yeah. They do that often in criminal cases as well. I've seen that one a lot.
They've never gone into this from the beginning. For almost 10 years, they've gone into this with the attitude of we're not going to cooperate.
Yeah.
Even though these are the best of the best on both sides. They're not going to talk to each other in good faith to try and resolve this for the benefit of Arizona taxpayers.
Right. Yeah.
And just a note on taxpayer piece, this case is, echoing Stacy, is one of the most litigious I've seen, and there's been, a lot of these class action cases become litigious, but this case may hold one of the records for the number of times that it's gone up to the Ninth Circuit, which is the higher level appeals court in San Francisco. And of course, anytime you do an appeal, that adds cost on both sides. Jimmy, do you know how? I think is it 5? We're up to 5 times it's gone to the Ninth Circuit, different aspects of this case?
I think there were almost that many rolling at one time. So I wouldn't be surprised if it was more than that. I think maybe last time we talked about this, but I remember being in that appeals court and the judges were laughing about how they were confused because they couldn't quite place like, oh, which appeal is this from the Department of Corrections on Parsons? They were literally joking about it. So there have been quite a few. And yeah, everybody, you're paying for plane tickets to San Francisco and transportation and all the hours that I'm sure go into the appeal process, which is quite extensive. And again, we're paying outside counsel for that.
Yeah.
And one final thing on that too is the things that the department is appealing. You have to remember are things that they agreed to in the first place. They agreed to say, okay, Judge Duncan, you're going to oversee this trial. Judge Silver, you're going to oversee this trial or this settlement, and we'll abide by the terms of it. And then they figure out what the terms are, and they say, we don't want to abide by those terms anymore, so we're going to appeal that. And the judges have brought that up quite a bit. It's like you all went into this agreement, and you're not abiding by it, and that's on you.
And I do remember too in one of in the contempt order that I believe it was the contempt order from Judge Silver, the second contempt order that was placed against the state for noncompliance. She at one point in her decision started talking to the taxpayers of Arizona, saying that you guys are the ones paying for this and this is harming you and something along that line. Does anybody remember what she said specifically better than my memory? It was something along those lines, right? Jimmy, did you have it?
Yeah, I was trying to pull it up here, but
Okay.
yes, the extent of it was basically like, the Arizona taxpayer should know that, this is costing them a lot of money. Sorry to lean in. I'm trying to read this document here. Come back to me. I'll give you an assessment in like 30 seconds.
Yeah, no problem. It's extraordinarily frustrating. So what we've outlined in this episode and the one previous is that when we think about this civil litigation, we have these ideas of what civil litigation looks like. We have an idea of what lawsuits look like as a lay, as the general public. But what most people don't know is the extreme difficulty there is in prisoner civil rights cases, and we've talked about that. And we talked about higher burdens. We've talked about Supreme Court cases that have set out enormously high burdens and have made it difficult to litigate and all that. But we also talked about the Prison Litigation Reform Act, and I want to talk about that. Jimmy, did you get the quote before I ask this question? Okay. So Billy, let's talk about the PLRA again for a second. Stacy brought up the requirement to exhaust administrative remedies, exhaust grievances in there. Now, grievances initially were a good thing. If most people have heard of, I think in pop culture, it certainly was made a big thing, that in 1971 at the Attica prison, there was a massive riot because conditions of confinement were so deplorable at Attica. And from that, people were killed in that riot. They stormed it with the government. It was an extremely horrific event. But what came from that was that they had determined that the men that were incarcerated at Attica had been trying for years to tell the prison officials about problems inside the prison that were causing harm, and the prison officials never listened to them. And so from Attica, we get this grievance process. And so initially it's set up to be a vehicle for people that are incarcerated to talk to the incarcerators and tell them about problems and have a resolution process. That was then codified in this 1994 law. and then it was turned around and is used as a weapon. So it was a solution that has now been turned around as being weaponized against people in the Department of Corrections because it's used, by what I mean by weaponizing is, as Stacy said, it keeps you outside of the court. You don't ever get your day in court if you don't successfully traverse this extraordinarily complex grievance process inside the Department of Corrections with really short time frames and all kinds of requirements on it. So that's one of the hurdles. But there's other hurdles inside that PLRA. Billy, can we talk about what those other hurdles are?
So Stacy might be the more precise expert on the details of the PLRA.
Okay.
And I might kick it to you, Stacy, but I will put a plug in actually for Stacy on this very topic, this general topic, which I think you're getting at, John, which is kind of access to the courts generally for prisoners. And, our system of justice is premised on, if you can't resolve your dispute through private means, like peaceful private means, like negotiating or grieving, you always have, the notion is you always have the courtroom door is always open to you. And this may have started in some ways before the 90s, but really culminated in the 90s, where you had both at the state and the federal level, courthouse doors are closing, and the PLRA is one example that you point to of this happening. But also, interestingly, alarmingly, in our system, we think of the reason why we have the United States of America is because you have state systems and you have federal systems. You have the federal Congress, you have the state legislature. Well, the same is true of courts. You have the federal courts and you have the state courts. And the idea is that in most instances, outside of the prison context, you can choose. There's limitations, but for many things, you can choose. If you're beat up by the police, for example, in the outside world on the street, and you want to sue the police officer for your injuries, you can choose. You can say, I'm going to go to state court, or I'm going to go to federal court. I'm going to make my attorney and I are going to make a strategic decision on which court to go to. Well, what happened in the 90s is you had the PLRA, and you also had the Arizona state legislature basically did the same thing. They closed the courthouse doors through an obscure law. And that's where I'm going to kick it over to Stacy and put a plug in for Stacy, because Stacy's actually litigating this precise issue, which is to say, and I'll let her talk more about it, but to say, look, you're closing the courthouse doors at the state and at the federal level, and so basically you're closing them at both avenues. You have to keep at least one avenue open in order to have like a democratic society. So Stacy's going to be arguing probably in a few months this issue, but I'll let her talk more about it and the PLRA.
Very good.
All right. Well, there's a lot to talk about there, and I know we're kind of wrapping up here, but one point that I want to make is that the reason that we have a civil legal system in the first place is to try and prevent physical violence between people, to give people an opportunity to resolve their conflicts in a civil manner. And nobody needs this more than prisoners, because they don't have a lot of options for resolving. They can't walk away. They physically cannot walk away from a conflict. So if we don't want prisoners to riot, if we don't want them to be fighting each other, if we don't want them to be assaulting prison staff, they have to have an avenue for redress of their grievances. And so with this requirement that they exhaust grievances, it's turned from an opportunity to resolve their differences to a means that the prison can prevent them from getting justice at all. So, like I said, if you don't adequately exhaust grievances or properly do it, your case gets thrown out. And so you're out of court, done. And so then, if you're mad as hell about something, the only option you have left is physical violence. And if somebody's mad enough, sure, they're going to go there. So it's important that we have doors to the courthouse open for people who need it. If we really are committed as a society to civil resolution of conflicts, there has to be an adequate avenue for that. In terms of the other ways in which the PLRA keeps prisoners from resolving their cases in court. One of the worst ones is the 150% rule. So if you bring a case in court and you win, you're normally entitled to all your attorney fees, and the other side has to pay them. But if you're a prisoner and you bring a case and you get over all of these hurdles, you've exhausted grievances, you've won summary judgment, you all of this stuff, and you get to trial, you win the trial. And the 150% rule says that the attorney fees are 150% of your actual damages, or your actual hours, whichever is less. And a lot of times in prisoner cases, juries don't want to give a lot of money to a prisoner. And so they'll give them what's called nominal damages, and that's $1. So you put in all this work on a case that has merit, and the jury says, yes, it's got merit, and you get paid $1.50.
Yeah.
So obviously that's not going to incentivize lawyers to take these cases.
Right.
So with all of the hurdles and everything, that's difficult. It's difficult enough for, somebody to run their own case. But, when you're not gonna, you maybe you manage to get a lawyer or something, but, no lawyer is going to want to take a case when they think I'm never going to get paid for this.
Right.
So that's another way that, it is very difficult for a prisoner to run a case on their own without a lawyer and get anywhere.
Yeah. It's extraordinarily difficult. It's extraordinarily difficult to go through the grievance process. It's literally what I did every day, was helping people navigate the grievance process and then navigate the court process, which is in and of itself, again, extraordinarily difficult with extreme time frames and all kinds of stuff. And so it is literally trying to move a mountain for people that are incarcerated. And that's that's not even with all of these other rules that are in place. So it is extraordinarily difficult. And so they disincentivized legal representation by putting the 150 rule in there. They make it extraordinarily difficult or easy to throw out a case by putting the PLRA exhaustion requirement in there. But not only that, the United States Congress also put very strict limitations on what a court can do in certain instances. Can you talk about that just a little bit?
Yeah, so when you're talking about a case for injunctive relief, the court has to, if they're going to grant it, it has to be narrowly drawn. So a lot of the motivation for the Prison Litigation Reform Act was to keep these prison administrators from being overburdened with these issues. And so they don't want the courts to be overriding the decisions of prison administrators and have the courts running the prisons, essentially. And so they say that the PLRA says that courts have to narrowly tailor the injunctive relief to apply, only to this, to provide the narrowest relief possible. So even if a judge wanted to say, hey, look, this obviously is happening not just to this one person, but to everybody who's in this situation, they can't, because it'll get overturned.
Yeah. So in total, and this is what I want everybody to take away from that, is that the United States Congress in the 90s made it extraordinarily difficult to win one of these cases, even for attorneys. And the court, the judge, is limited in what relief that judge can give. And I think a lot of people don't understand that, except oftentimes in the terms of mandatory minimum sentences in criminal law. They understand that the legislature put these mandatory minimums in that a court has to sentence you to, but that also is existent here exists here in civil cases, that the United States Congress has put strict limitations on what courts can do in these types of cases as well. And so all of these things combine together. And so I think it makes it patently obvious why states like Arizona, who want to operate in these deplorable ways, just do it, and they do it with no compunction or no worry at all, and out in the broad daylight, because there just is no recourse against them on an individual level. The only time you get any type of big recourse is in these class action lawsuits, and even those are narrowly, like as Stacy just said, narrowly tailored. Jimmy, did you ever find that? Did it ever come up? No. Okay. So I do want to go ahead and close up, because we've been at it for an hour and there's so much more to cover. What we're going to do, we will be back again next week, next Friday, same time, 5:30 here on Facebook Live. And we do have a number of questions that have been coming in from those of you that have been watching these. We want to get to most of those next week. We wanted to lay down a lot of information about what's going on in these trials, and we wanted everybody to understand what complexity and what difficulties not only does the plaintiff class have, but what the court has to determine in this matter. And so a lot of this episode and the episode before has been educational and talking about these issues. But we have been getting great questions from you out in the audience, and we want to encourage you to ask more questions. And next week, we're going to focus mostly on external questions from you all. So please hit us up on our Facebook feed, hit us up on Twitter. You can DM us, you can do whatever. Get us those questions that you want to ask this extraordinary panel about what's going on in this trial and where we're going to move. And we do have a bunch already. There's a couple other bits of business that I want to talk about. Tomorrow, Saturday at noon at Margaret T. Hance Park in downtown Phoenix at 67 West Culver Street. Is going to be the first annual ATAC picnic and fundraiser. We're going to be going from 12 p.m., so noon to 2 p.m. tomorrow. Everybody's welcome. Please come down. We'll have hot dogs, hamburgers. We have prizes to give away. We have speakers that are going to come talk. Representative Diego Rodriguez is going to come and speak. Brian Radford, who is running for the legislature in LD11, is going to come speak. He is a former correctional officer and worked in the Department of Corrections for, I think, a couple of decades, and has a tremendous amount of experience there, and is all about prison reform and oversight reform with us as well. Beyond that, on November 23rd, 2021, here on Facebook Live at 6 p.m., we're going to have a panel with two former correctional officers, Brian Radford being one of them and Mindy Krasinski being the other one. Like I said, that's about 50, 60 years of combined experience inside the Department of Corrections. They were CO3s. Brian Radford was also CO4. To those of you in the audience that know what those are, they will be here and they will be answering all kinds of questions. So if you want to give us questions about that panel, we would be more than happy to receive them. And then on December 14th, 2021, we are going to have our lawmakers panel, which we will have Representative Rodriguez and Representative Walter Blackman, a conservative and a Democrat, be on the panel, and we'll talk about oversight legislation there. As always, Arizonans for Transparency and Accountability in Corrections is about passing comprehensive oversight legislation. We want to set up a independent external ombudsman office and a citizen-led legislative committee down at the legislature. We have legislation, and we will be proposing that legislation up again this year, and we will ask you all to support it, so please pay attention. The legislative session will begin in January, and we'll be asking everybody to strongly support that legislation. We want to get this across the finish line so that we can actually get some sort of transparency and accountability in the Arizona Department of Corrections. Again, I want to thank Julie Gunnigle, Billy Peard, Stacy Scheff, and Jimmy Jenkins for joining us. Again, you all are amazing. Extraordinarily happy with you all being here, and thank you so much for spelling all this out. We will see you all next Friday. Everybody, have a wonderful weekend, and hope to see you tomorrow down at the park. Goodbye, everybody.